Let's get started. Welcome back. Happy Thanksgiving to you. Probably any Thanksgivings you've ever had before.
Very grateful.
Don't be obnoxious and argue like a lawyer at the dinner table, no matter how much you're crazy. Not good. The assignment for next class when we return after break is we may get through 690 today, probably won't quite get there. Then we're going to jump and do 5 pages on the particular rules involving lawsuits against the federal government. As we're talking about sovereign immunity, that's the last piece of it. And then we're going to go into the beginning of our discussion of premises liability. We talked about a little bit before. We talked about slip and fall law in the context of constructive notice and res ipsa and the like back when we were talking about circumstantial evidence. We're now going to dig in more deeply, and these pages introduce us to somebody we've seen before, which is the trespasser. But now, instead of the trespasser being sued for the trespasser is suing for the injury that the trespasser receives on the defendant's premises. And you'll see there's a bunch of little technical laws that rules we're going to go through pretty quickly. And then the class after that discuss the remainder of premise liability, and then have one more major topic to go through before the exam. I think I may have said to one group or the other that I'm going to give you an exam to look at over Thanksgiving, and it occurred to me it's really a bad idea because there's a bunch of stuff on the exam that you haven't gotten yet, and if you sit down and start taking an exam with stuff on there that you haven't covered yet, it's not going to be a very useful exercise for you. So I will get it to you at the end of classes, and I still encourage you to use that as a study aid when you are done with your outline. Don't use it to improve your outline, because you get one example from me of what an exam looks like, and it's really the optimal training ground for you. And I know you're curious to see what it looks like, but you already know multiple choice questions. You already know how excruciating it can be to answer a legal concept in 15 words or less. And so the only thing you haven't seen is a big essay question, but it doesn't make sense to show that to you. It's going to potentially cover material from the first day to the last day. So I'll get it to you in plenty of time. I'll also let you know about availability the week before the exam. I'll have a time for a review session. I'll also have office hours at various points along the way. Okay, so Mr. Harrington, starting with you. Thanks for walking with this morning. I'd forgotten I hadn't called on you yet.
Session was all
So we're on 7B, right? We're talking about situations where the normal rules don't apply because of something distinctive about the plaintiff's lawsuit. Last week we talked about the type of injury, which was the negligent infliction of emotional stress without a physical impact. And then we talked about economic harm without a physical impact and the rules that have evolved there. Now we're pivoting to the other part of 7B, and it will take us really all the way through the rest of the semester. It's special rules tied to the status of the defendant. And we've been talking about it really since very early on when I said, what do you think would be the rule when the king runs you down with his chariot? And you go, well, I guess they probably can't sue the king. Well, this idea of a status of defendant creating special rules is now finally center stage here today. So we're going to be talking about the idea of sovereign or government immunity. And let me just say at the outset that it is, as you think about it, government is all around us. The post office, the street maintenance, the schools, the products that get approved by the federal government. There's many, many ways in which the government might do things badly that could end up causing citizens injury. And it's a very complex area. We're only going to skim the surface. I believe I said before, we actually have a whole course on suing the government here. So you're going to get a little taste of it. I'm going to pick out a couple of things that I find interesting, particularly involving police liability today. But just rest assured that there's a lot of stuff out there, and it's a very important part of the practice of law because, as you will start to see, the rules can be quite different. So here's the history, right? The king, the divine right of kings, the king said, you can only sue me if I let you sue me. And so England had this, and it made sense, right? The sovereign immunity, the sovereign makes the rules. If the sovereign doesn't want to get sued, you don't sue the sovereign. And so England had this established in its common law, and now, not now, but in the 1700s and 1800s, like a lot of other common law concepts, it came to the United States. Even though we are the sovereign, we don't have a king. There's like a fundamental historical gap between what made sense in England and what made sense here. But nevertheless, as we'll see, there are some policy reasons, regardless of who has the ultimate power, the king or the voters, where the rules are in fact really quite separate from those of general tort law considerations. So we're going to start and I'm going to lecture for the first 3 or 4 minutes on state law. There's 3 possibilities: federal, state, or local, right? There's 3 kinds of government. We're going to start with state law. And it turns out that almost all states have passed a statute or have a judicial decision that said no longer sovereign immunity. Sovereign immunity is gone. But in no state do we treat all defendants, exactly the same as we would treat Walmart, exactly the same we would treat a private party. So while sovereign immunity is gone, there's a lot of residual doctrines that mean we still have to look very carefully at how to handle this particular defendant. So what has happened is the states have carved out areas where you can sue the government for negligence, and there are areas where you can't sue the government for negligence when the government is the state government. And the language is the courts are looking for a uniquely governmental activity. You can't sue even if there's a waiver of sovereign immunity, if the injury arises from a uniquely governmental activity, then, as you might guess, the arguments for sovereign immunity are at their strongest. So, claiming an injury from voting, I don't mean the premises of where you vote, I mean from the outcome of elections. Can't do it. That's a unique governmental activity. How courts are organized, what is a lie under oath that is harmful to your reputation, things that might well be actionable are not if they come up in the context of legislatures' work, the work of courts, and the like. And then a subset below this, and this is the through line for the next couple of classes. If the defendant's activity involves roughly what we'll call the exercise of discretion, courts will allow lawsuits for injuries to proceed. So here is the simple 2 little pro and con. Supposing, Adam, the government designed a highway with a curve in a certain place, and it turned out that people started dying because the curve was too steep. That's case 1. Case 2 is the city installs a traffic light but doesn't maintain it. In both cases, plaintiffs are injured. In both cases, the plaintiffs want to sue the government for their negligence. Which one's more likely to be subject to a sovereign immunity kind of argument, and which one is not?
I would think the traffic light is more likely to be subject to immunity.
Okay, so there's something distinctly governmental about how to maintain traffic lights. Like how often to check them, what to do when a report comes in. Does that really go to the heart of government discretion? Now
Maybe
flip it.
not.
Compare that to deciding where a road goes, or the curve of a road, or where to put a stop sign.
Well, my reasoning was that the traffic light is almost in the exclusive control of the government,
That's
whereas
true.
any
I'm not saying you weren't negligent. I'm saying should the decision about how to maintain traffic lights be something that can be second guessed by juries, as opposed to the decision of where to put roads, or what kinds of banking or vision lines might be appropriate.
Yes.
So basically, one is more likely to be considered appropriate for sovereign immunity. That is the discretion exercised in where to put roads. These are balancing lots of things. But there isn't a lot of discretion involved in checking to see if lights burn out. That's the kind of thing that is done in the private sector all the time. And so in one case, it would be considered to be a governmental function and subject to the immunity for state decisions. And the other would be something involving the exercise of discretion, not involving the exercise of discretion, but sort of the sorts of things that go on in the private sector all the time. Sweeping floors versus how many people to assign to respond to a natural disaster. Might there be a different, might one be continued to be immune and the other one not?
Right, the natural disaster would be immune.
Why?
Because we've all swept the floor.
I'm sorry?
We've all swept the floor. That's not exclusively governmental.
Yeah, I mean, is there a sophisticated cost-benefit analysis that we hire people from government or want our government to do for us in one case, and the other one is sort of a routine, unsophisticated, important, but nevertheless not a complicated kind of decision. And so that line is one that will be between state and federal courts. And I'm not going to test you extensively on this, as I said. There's a whole course that talks about this. Local government, this is where we're going to spend today. It turns out that local governments never were considered to be sovereign. They are products of state law. So you'll find a statute that identifies the way in which, in Rhode Island, you can organize your government and become called a town or a city. I forget what the terms are in Rhode Island. But the same basic arguments are here, because we might well be nervous about exposing local government with all the thousands of things local governments do that involve potential harm to citizens from having their decisions second-guessed by a jury in a tort action. So again, we're looking for the same kind of distinction between discretion and sort of mechanical day-to-day behaviors. So for example, if the snowplow runs into you, Adam, as opposed to the snowplow didn't get to your house, which one's more likely to be subject to a continued immunity?
Didn't get to your house,
Why?
I think.
Why?
Because there's some governmental discretion in that. They have to plow the roads that are more frequently traveled as
Yeah.
opposed to a residential road.
And do you think we ought to have a jury saying, oh, Harrington's Road ought to be plowed before, you only got so many plows, you only got so much money. Right. So you're looking for something, again, looking for discretion in the through line as what is going to be the characteristic of the kind of case that courts are going to be inclined to keep out of the tort system as opposed to those that are allowed in. The language here is often a couple different terms. Proprietary or private functions on the one hand, and governmental functions on the other. But I just think for your purposes, I'm not going to drill you on the language, just be looking for whether the decision is characterized by an exercise of discretion. It's obviously going to be boundary disputes of how much discretion is going to be enough for it to cross into appropriate for sovereign immunity. But planning, decisions about allocation of resources, things like that tend to continue to be immune, and things that are like more mechanical carrying out of policies tend to be appropriate for tort suits. Now, two important things to add in, and again, we're not going to test you on this, is that, as we'll see next class, even if you don't have sovereign immunity as a bar, a 12b6 bar to the plaintiff's claim, you still might face two very different approaches. We've seen this sort of before with workers' comp, right? If you fall into this category of workers' comp, we take you out of the tort system. Well, even if you can prove that the particular defendant's act was private in nature as opposed to policy making, you still typically have to go to a special court with no jury, and you may have a cap on damages. That is to say, even when the waiver of sovereign immunity is no longer an issue on the actual merits of the case, there still may be special impediments to the plaintiff getting full compensation because you don't get in front of a jury, and while it's not the hearing officer or the judge may not be as tight-fisted as workers' comp recoveries are. They often are not as generous as it would be if you were suing for identical injuries, identical conduct against a private party. Again, just know that the procedures and other stuff around suing state and local governments is different. A quick introduction to something you probably know vaguely about. And so here's what happened. So, as you know, at the end of the Civil War, in the South, which had resisted federal authority, it turned out that the people that were running the governments in the South, many of whom were basically still disloyal to the federal government and certainly hostile to minorities and carpetbaggers and Republicans in their midst, turns out sheriffs wouldn't arrest whites who were convicted, who were committing crimes against blacks. It turned out that juries were all white and they wouldn't ever convict a white person. It sounds familiar, but this was really dramatically true in 1866, 1867, 1868. The Klan was ascendant. Even government officials who wanted to do the right thing were worried about having their houses burned down if they did the right thing, that is to enforce the local laws over there. So Congress passed a series of statutes in the late 1860s and early 70s, which are roughly called the Civil Rights Acts. And the most famous one in which you'd have to write this down is 42 U.S.C. Section 1983. And what 1983 does, it says, injured person, you don't have to go to state court, because we're worried that state courts won't give you a fair shake. You're going to have a federal cause of action in federal court for violations of your federal rights, either under the federal Constitution or the state Constitution. So, again, part of this course you might consider taking is all the special doctrines that go into 42 U.S.C. Section 1983 litigation. It's incredibly complicated, with all sorts of doctrines about in what circumstances what state employees have, or local government employees have what kinds of immunity. But it's an incredibly powerful way. A whole lot of the civil rights victories of the 60s and 70s, 50s and 60s and 70s, were either directly or indirectly a result of this statute and a parallel federal statute that allowed the federal government to bring criminal indictments against white public officials who failed to carry out the law appropriately. So just be aware. But those are constitutional rights that typically don't involve slip and fall or car accidents. But that involves things like murder, that involves things like lynchings and the like. And those statutes are on the books, and they can be very powerful as well. Okay. So now, finally, Adam, page 684, the case of Riss versus New York. And give us the fact of the case.
Sure. Linda Riss, the plaintiff, described as an attractive young woman, was being harassed by an attorney, no less, for upwards of 6 months. He was making advances of her. She was declining. He threatened to have her killed or maimed if she didn't succumb to his advances. Fast forward, she gets engaged to another man. The night of their engagement party, she receives a call threatening her that this is her last chance to come to him instead. She calls the police that night. She had called the police multiple times throughout the 6 months.
Let's stop right there.
Okay.
Had the police ever responded in any kind of way to these earlier calls reporting the threats? Did they blow her off in the earlier calls?
The dissent makes mention of an initial investigation,
Yep.
But after that initial investigation, they had not lended much credence to her calls.
Okay. And so on the night of her anniversary, of her announcing her engagement, pick up the threat.
She received a phone call that it was her last chance. She was distraught. She called the police again. Again was kind of blown off this time. The following day, someone threw, I believe, acid in her face, blinding her in one eye, basically permanently disfiguring her face.
And did the police finally do something?
Yeah, they ended up giving her protective detail for the next 3.5 years after that, because they believed that her reports were credible now.
And also this guy had the means and the wherewithal to carry things out indirectly.
Yeah, he paid, I believe it said a hired goon.
Three guys paid $2,000, which was going to change back in that time. Okay, so if you were to see this on the final exam, you start to say, is there obviously a battery claim available here for the plaintiff?
Yes.
Which was?
Which was the harmful and offensive touching of a person by acid.
So those guys, that's an easy battery claim. How about Pugac, the lawyer? Burton Pugac, a miscreant masquerading as an officer of the law, or something like that. We haven't really talked about this, right?
No, we haven't.
How would you attack it?
That's a good question.
He's not a bystander.
No, he's certainly not a bystander, but he's I don't know, would it be vicarious liability because he employed the person to do it?
Okay, might there be sort of a negligent entrustment or an argument that through your employee you created a reasonable risk by instructing him to do this and giving him the incentive to do it and giving him the money to do it? You have to cobble it together, right? It's not an easy argument, but intuitively you've got to assume
It's got to be something.
there's got to be something there, okay? But might the thugs and might Pugac not be deep pockets?
Probably not.
Okay, so now the question is, under what circumstance can you sue the government? And give me the best argument here that you can for the plaintiff. Take the facts and shape them the way you would like to shape them.
I've been telling you for 6 months something like this was going to happen. You repeatedly ignored my request for protection. And because you've ignored my apparently very credible reports, I'm now permanently disfigured.
Right. And do you think you could come up with an argument that was negligent behavior on the part of the police to reach that conclusion?
I would think so, yeah.
Good. Anyone read the papers recently? Or you can read papers. Read the online news about the shooting in Thousand Oaks, California? That was an eerie successor to this. Anyone know what happened to that guy? The cops yeah. Yeah.
The security officer.
Pick up. I'm sorry.
Was that the one with the security officer was shot?
No, I mean, my bad. But basically, yeah.
Weren't they warned about him?
Yeah, they went
dangerous.
to his place. They got a bunch of calls about this guy was acting erratically, and he was a veteran. And, you know, PTSD specter comes up in your head. They were trained with weapons and the like. So police actually, like Linda Riss, investigated, right? And apparently concluded there wasn't a basis to commit him or otherwise arrest him. Okay. So, on the face of it, when you saw these facts, Adam, did you think this was going to be a pretty easy case for the plaintiff to at least get to the jury?
It seemed that way initially, yeah.
Yeah. Does the plaintiff get to the jury?
The plaintiff does not.
Okay, 6-1 decision. So this isn't even a close case. It's another one of these situations where you go, our intuitions coming into tort law says the police should have done something here, and they didn't. But we're starting to find out now, 3 months into law school, that there are these more subtle counter-arguments or pressures that make us have to rethink, among other things, in this case, the relationship between the police and the citizens. And I'll just ask you, I think this is a fair question. Is there an expression on the doors of police cars or on the uniforms of police that might support your intuitive argument that this is a situation where the defendant, cops, should have done something to save Linda Riss?
To protect and serve?
To protect and serve. Did the police protect and serve here?
They did not.
Pretty clearly, they dropped the ball. So we have this understanding of what police are supposed to do, and now we're going to have an actual on-the-ground piece of litigation when someone says, you show me the protection and service. Don't just turn your back on me and look at the consequences when you make those decisions. So I'm going to ask you to take the government side here, the majority side, and I'm going to ask Kendall, who's behind you, to give me some counter-arguments, some pushback that come from the dissent or from just responses to Adam's argument. So let's go, Adam. What might be some reasons why courts are going to go slow here? And recognize a 7B limited duty for police for people who are injured by criminals.
I think the biggest one is the policy argument. It's kind of
So they're all policy arguments.
a floodgate argument.
Let's talk about it.
Okay, if, the police were held to a duty to respond and offer protection to everyone who was worried about being harmed, the resources are limited. We can't provide security detail for every private citizen who's fearing an injury.
So that means that we're going to let the police be negligent in how they carry out their cost-benefit analysis about how to spend their resources?
I know because there's some discretion involved. It's uniquely governmental.
Well, no, wait. If you win the 12B6 motion, we don't talk about this discretion. It's just the issue's taken away, right? This is an argument for no duty or a limited duty. But let's stay with that. Why might the idea of discretion that we talked about a few minutes ago be consistent with the position the majority takes here?
If the police were to receive simultaneous phone calls, one of someone has received a phone call threatening harm to them tomorrow, and another phone call is this person has a gun here now, they're going to go respond to the call of the immediate danger.
And that second person may well be killed.
Maybe.
And, well, they will be killed and not have a lawsuit as a result. That's the position that he's taking here.
Yes.
Ken, do you want to push back on that?
I mean, the police have a duty to protect and serve each individual. And so this is an individual who brought forward a claim and went to the police and said that he was worried about someone coming after
But
him.
respond to his floodgates argument. You're right. You're stating the facts, and the facts do support our intuitive inclination to recognize the duty here. I mean, is the world going to come to an end if we have tort liability imposed? Haven't we seen defendants make these kinds of arguments before? Oh, the sky is falling. Oh, if I have to behave reasonably, we'll no longer be able to fill in the blank. Have we seen examples about that? What are a couple examples of floodgates arguments that have been made but rejected that might give you some solace when a defendant, like here, makes a floodgates argument? Nobody? Yeah, John?
Emotional distress.
Talk about it.
That it would bring up fraud, but that they could do some medical examination to prove that it was credible.
Good. Can you, by analogy, identify some protection for the police that would remain here even if they did have a duty? Does plaintiff automatically win these cases just by saying the police didn't do what I wanted them to do?
Yeah, they can still say that, that they do a proper investigation and also look at the person making the report to see if they are credible, or if they're just always calling the police saying people are out to get me in general, where she had a specific...
So, just because we might knock down the immunity doesn't mean the plaintiff will win in all these lawsuits. Supposing we have Harrington's hypothetical, that the cops had two calls, one for an actual credible armed threat now and one for a threat in the future, and they decided to respond to the threat now. Weren't they reasonable? And if you're reasonable, do you pay in a negligence action?
No.
So defendants can still be protected here. Wasn't this true of the Tarasoff case? We had some people sitting here saying, oh, the world's coming to an end if psychiatrists have to use reasonable care to protect strangers with a therapeutic relationship. And now, 40 years later, every jurisdiction one way or the other recognizes that because they, in part, said that's a floodgates argument. Let's respond to this a little more calmly and say the plaintiff still has to prove negligence. And why, Kendall, might it still be a burden for plaintiffs in these cases to prove negligence? How do you prove negligence against a cop? What will the standard of care be? That's a nice little review of some concepts.
Had a reasonable duty to, reasonable duty to take care of or protect the citizens.
Okay, and how do you prove it? How does the plaintiff prove that a defendant was negligent? Come on, just go back to a month ago. You gotta be knowing this stuff by now. I know you're like completely emotionally deadened right now, but I need someone to help them out. How do you prove negligence? You gotta know this.
What the reasonable cop would do in that situation.
Yeah. Okay, and how do you prove that?
By seeing if,
Do you propose an untaken, safer alternative?
yeah,
And then you argue what?
whether or not they were negligent.
You're fading on me. Give me a hand, come on. Otherwise, I'm not gonna talk about it anymore. Yeah,
The PTO analysis.
come on, let's go.
You can say that providing a burden to watch this woman at all times would be outweigh the benefits of, you know, these seemingly nebulous threats that she had been reporting.
Okay, do you think you would want to argue on behalf of your client that expert testimony says that what the police did in this circumstance was a reasonable thing to do, given you had multiple threats, one immediate and one in the future?
Yeah, you can say that certainly that the custom was to respond to the immediate threat.
And could evidence of custom be admissible for a defendant to prove they were non-negligent?
Yeah.
Might the plaintiffs have a hard time finding an expert here?
Yeah, certainly.
Who's going to volunteer on that one? Yeah,
You have a conspiracy of silence.
talk about it.
Well, the police are all
If we think it's powerful with doctors, what do you think it is with cops?
even more powerful.
The thin blue line. You cross that line, you align with the other side, you're a snitch. A lot of the same values that the street has in gangs, police have. Now, they're not breaking the law, but this notion that we stick together, it will not be easy for the plaintiff to find an expert who will be credible to testify that the cops did something wrong, in at least a lot of cases where there's a judgment call about how to spend scarce resources. Okay? Floodgates, give me another argument. There's a separation of powers. What does that mean? Well,
Stay in
common
that
law
lane.
101.
The court is saying that this should be an executive or a legislative decision.
Come on, talk about it. What should be? Be more precise.
Imposing a duty
Okay.
on the municipality in this case.
Well, let's not, of course, if the legislature passes a statute, the police have to do with it, but why shouldn't courts be recognizing duties in this particular circumstance? Vis-a-vis the other branches. Why is the duty here, it's a correlate of floodgates, Philip?
Well, I was just gonna say, I guess that the police power is kind of like a function of the executive, so it seems like it would be improper for the judicial.
Okay, so might we be nervous about one branch of government allowing liability of another branch, just from sort of a separation of powers perspective?
Yes, I think
Should
so.
courts not be meddling in the executive branch decisions about how to deploy police? Good. Anything else like that? This is a variation on floodgates. What's going to be the major pushback that cities are going to, major argument they're going to make over this idea of opening the door even a crack for liability of failure to arrest? Tanner? Sorry.
That's okay. Take it all back, sorry.
I didn't mean to move my pelvis quite so close. I know the focus my belt. Come on, yeah,
That they don't have the money or the resources.
come on.
To have like cops on the streets everywhere responding to like every call, giving people like so much protection every time that they say that.
Well, there are a lot of people who might be victims of crime in a city tomorrow.
Yes.
Might be a lot of situations where people would really feel threatened and would love to have some kind of extra police security to guard them from this danger. might some neighborhoods,
Yeah.
might some times, might some businesses. And so aren't police already making sort of a cost-benefit analysis about where to put their scarce resources? I'm assuming that when they talked to Linda Riss months before, they didn't stop being police after that. They went back to being police, and they were looking at other situations where their resources might be necessary. And might we be really nervous about letting jurors, after the fact, when Linda Riss is sitting there with her scarred face, and we know that Pugac was bad, unfairly tagging the cops with 20/20 hindsight, rather than giving them an actual opportunity to listen seriously to how hard it is to decide whether to help Linda Riss or somebody else.
Yep.
Yes.
Then we'd be punishing for bad outcomes. So
Right.
it's like-
Is that a real danger here?
Yes.
Might juries listen or look at Linda Riss and feel something, and the argument be plausible, but government let her down? And the argument's plausible. You wouldn't want this to happen. All those arguments are powerful emotional arguments that are potentially there in a negligence action, assuming you can get the expert witness there. And then we have juries deciding where to put $1 million damage award. And why might that be a problem? Let's assume for a second we don't have significant caps on the amount of damages that can be awarded. Let's assume there are juries involved. Where's that money going to come from? Yeah,
Taxes, city,
taxes.
the city budget itself.
So should the judicial branch impose significant financial liabilities on another branch, which can only be dealt with by spending more money? Is that fair to all the taxpayers to make us have higher taxes to pay Linda Riss's damages? Now, you're not enthusiastic about that description, I assume. Right? She's got a grievance here.
Right.
This is real. But Linda Riss isn't the only person that's going to be a victim of crime tonight in Rhode Island. And imagine New York City, or imagine Chicago. How much danger there is out there, and how we might be reluctant to let police, or put police on the hook when they fail to stop crimes. Even if we intuitively think that's a crime that should have been stopped, which may well be the case in Linda Riss's situation. And Adam, is a bright line. There's something attractive about this rule that says, in general, police failure to arrest will never lead to civil liability for the victim of a crime that arrest would have presumably stopped. Is there something handy for the courts here? Why 6 votes here, 6 out of 7, when the facts are so tragic? I think floodgates, but we can argue about that. Taxation, any civil liability might require additional taxes, so maybe that's not by itself. But why might this be an attractive, bright line rule? You show me a failure to arrest, I'll tell you no duty. Yeah.
Would it also hinder their productivity and their efficiency as doing their job as a duty to be policemen?
Okay. So does this free up police to make their own cost-benefit judgments about where to put scarce resources without ever having to worry about being second-guessed about a decision? And does that mean the judicial system is basically going to let the executive branch handle law enforcement? Now, we're going to see, or I'm not going to say, I'll tell you, if a cop shoots somebody, or if a cop runs someone down in a high-speed chase, the answer may be different. And why might those cases be different? Adam?
Why might those be
Go
different?
back to 7A. How are those cases different than this case?
Because there's a relationship. There's an undertaking of the assumed risk.
If I shoot a citizen, what's my undertaking to that citizen?
As a police officer?
Yeah. Well, it ricochets and hits the citizen. Aaron?
Well, I was gonna answer your original question that their conduct creates a risk of physical harm.
Come on. How is Rissa's case fundamentally different from a 7A perspective than from the shooting or the car crash case?
Well, in the shooting or the car crash, guns and cars are dangerous objects, and operating those involves a risk of physical harm versus, I guess the conduct in the risk case would be, I don't know, protecting her, I don't, like.
Give me the word for describing the relationship between Linda Riss and the cops in the failure to arrest cases.
It didn't create a risk of physical.
I'm sorry?
Their failure to investigate didn't create.
Fair enough. They didn't create risk, yeah.
Bystander.
Bystander. It's someone else's danger, we're just not intervening. And have we seen before a reluctance on the part of courts to force people into stopping dangers that other people represent? We saw Tarasov. Why might Tarasov be a stronger case for imposing a duty than Linda Riss's case? At least Tarasov as the cases have evolved, yeah.
The medical psychiatrist.
Good, come on.
The expert testimony of his mental state.
Is, despite their hand-wringing, that they don't know what they're doing, they are trained to predict violence. Is that a good argument with police?
Not particularly.
I'm sorry?
Not particularly.
Not as strong. Okay, what else? Yeah.
But aren't police also trained to know if there is going to be a danger, and that's why they.
Yeah, I mean, they're not trained the same way as psychiatrists, but let's sort of put that, that's a fair argument. I don't think it's the best one here. How is Tarasov different than Linda Riss's case?
Well,
Yeah, Benyon.
there was a special relationship.
Come on, yeah, come on.
Yeah, between the therapist and the patient.
Good, but did the psychiatrist have a real special relationship with the victim?
No.
Did Linda Riss have a special relationship with the police? Go slow. Recount the facts as Adam gave them to you. Would a case be stronger
Yeah.
if she was in the police station and the guy attacked her in the police station?
Of course.
Why?
Because he happened right there, like there's a special relationship.
Good, but is that what happened here?
No.
No, she's out living her life, having an engagement party. So she was a stranger to the relationship, like Jill said, a bystander. Who wants to push back on that argument? How is Linda Riss not a stranger?
Well, she called several times.
Okay, so she did step out of the crowd, and did police also respond at least once? Right, they respond at least once, yeah?
Also, the police has a duty to protect the public.
Well, that's the question. Should they have this duty that's a tort duty? Protect and defend, yeah, we'll see. What did the post-Tarasov courts do to limit the number of people that could take advantage of the Tarasov rule? Anybody remember? Yeah, Aaron?
Well, it has to be a foreseeable victim.
And often pretty specifically foreseeable, like you know the name of the person.
Right, easily identifiable.
And why did the courts do that? Why did the courts put that limit on the number of people the psychiatrists owe duties to in the post-Tarasov cases?
I think if there's like a sort of general danger, like I'm gonna go shoot up a mall or something like that, the psychiatrist, I just think it's very difficult to be able to prevent sort of an outcome like that where what you have.
And so we might well then limit the number of people that the psychiatrist has a duty to people that the psychiatrist could actually call up on the phone or go visit and say, I got to warn you that my patient is dangerous. Is that sort of thing feasible with police? And all the thousands of bad people they come in contact with on a regular basis. To go and actually personally seek out each person who's endangered by a bad person. If you're a gang member, as often as not, you're dangerous to some poor bystanding kid who's riding his bike. How are you going to warn him of the drive-by shooting when the bullet goes astray? So we're talking about tens of thousands of possible, in New York City, maybe 1 million possible victims. And we want to have those cases go forward when we don't have as clear a sense among other things, about the ability to actually predict who's going to commit the crime and who's not. Police are probably better at it than you and I are, probably not as good at it as psychiatrists. And the other arguments against, oh, by the way, this bystander, Jill, if you're Linda Riss, and you're living in New York City, and the courts tell you you can't sue the police because you're a bystander, you're a stranger, does that stick in your craw?
Yeah, I'm struggling with it.
Yeah. Why might that be a deeply troubling thing to say to not just this victim, but to somebody who is a member of your community? How is she different from Tanya Tarasoff? Tanya Tarasoff was a total stranger to Dr. Moore, right?
Yeah.
Is Linda Riss a total stranger to the police department? Vargas?
I say no because she had already placed calls.
Okay, so she has stepped out of the crowd. What's another way in which she's linked to the police department? Yeah.
There's records of her calling, complaint forms.
Okay, variation on that. Yeah.
But what about just the police's? Who else would the public turn to seek protection?
Good question.
Right. So I think that
Isn't that their job?
Yeah, that mere fact establishes a relationship where.
Is there an argument for an economic relationship?
Yes.
Yes. Yes.
She needs taxes.
Talk about it.
Citizens.
Yeah.
So she, in paying that, hopes.
This is how you put together an appellate argument, right? Pro, con, point, counterpoint. She's a stranger. Protect and defend doesn't go to any individual citizen. She's a stranger? Is she more of a stranger to the police than a person that walks in Walmart is and slips and falls in Walmart? We don't spend any time worrying about, oh, poor Walmart. They shouldn't have to defend their decisions about security they put in their parking lots or how many people they put into sweeping the floors. If you're negligent, you pay. So the idea of saying to a taxpayer that you're a stranger to government services seems to be pretty harsh. Tanya Tarasoff isn't giving Dr. Moore any money. Linda Riss is paying those police salaries in a very indirect way. Finally, this quote was in one of the family community cases we had the other day. But let me, Mr. Gordon, just sort of tee it up for you. If we tell an actor, don't worry, you'll never be liable for your negligence. That's a no-duty rule, right? Or a limited duty rule and no obligations in a particular circumstance. What does that do to our bedrock assumption that we reached about 6 weeks ago? That there's something good and special about making people worry about negligence liability. We make them worry about negligence liability to encourage them to behave reasonably. And the consequence if you behave unreasonably, you pay damages, so maybe you're going to be more reasonable going forward. If you give someone an immunity from liability, what does that do to the deterrent function that we think the negligence system provides?
It's gone. There is no deterrent.
Gone. How can we get the police to be better at what they're doing if we can't sue them when they screw up?
Yeah.
How's the second best argument? How might we get the police to do a better job even without civil liability because of this rule here? Yeah.
Vote for a different mayor that
There you go.
will do something.
Go to the ballot box. Throw the bum out. Does that get Linda Riss any compensation?
No.
But does it maybe get us better police behavior 3 years from now when a new police commissioner comes in and maybe responds differently to domestic violence threats than the previous commissioner did? So we get some behavioral change with government we don't necessarily get with businesses, but even then, you can not shop at Walmart, right? If the defendant doesn't pay, you can say, I'm not going to go to Walmart, I'll buy all my stuff at Target. Maybe Walmart then says, I better be careful because I know I don't have tort liability, but Target's getting my business, so I've got to behave more reasonably in that circumstance. And businesses do react that way. But we're not without our remedies to try and get police behavior to change, but it doesn't make Linda Riss whole, doesn't get her compensation. So now, Adam, the majority, even though they recognize here, oh, this is the language. It was in the charitable immunity case, Abernathy. Immunity fosters neglect while liability promotes care. Immunity fosters neglect while liability promotes care. And that's a core plaintiff's argument, saying if you give these guys an immunity, you're saying the system doesn't really care about how you behave, and that will probably lead you to be more negligent rather than less negligent. So, Mr. Harrington, in the actual risk decision, the court, let me give you the word. The holding in risk is called the public duty rule. The public duty rule. And what might that mean, the public duty rule? Meaning the cops have no liability for failure to arrest. Okay? What does it mean? Is there a duty in these cases when the court says no tort liability under 7B?
So I don't think they totally do away with the duty. Is there a limited duty?
We're going to go to that in a second. And actually, I'm going to answer the question because I didn't like the way I phrased it. If you understand this public duty notion, it's the idea that the police have duties to all of us generically as citizens, but not to any one of us. Seems weird, doesn't it? That we could have a rule that says a defendant has a duty to society to protect and defend, but it's not enforceable by the individual member of society. But aren't there exceptions? In the middle of the risk case, I've lost the page here. Page 685. Adam, the court says, you'll see there's a three ellipses and then for all these reasons, blah, blah. Then they say, quite distinguishable, of course. Read that, and then I want to play with that case of Schuster a little bit.
Quite distinguishable, of course, is the situation where the police authorities undertake responsibilities to particular members of the public and expose them without adequate protection to the risks which then materialize into actual losses.
So here are the facts. There's a guy named Willie Sutton. I'm so old. There were students that actually once knew about Willie Sutton. Willie Sutton was a notorious bank robber in New York City. And he was interviewed once and said, "Why do you rob banks?" And he said, "That's where the money is." And he was a legend, like Whitey Bulger was in Boston, like a bigger than life figure on the land. So the cops think he robbed this particular bank and put out an all points bulletin that anybody that has information leading to the arrest of Willie Sutton, it'll be much appreciated. And there were wanted signs in post offices and on telephone poles and the like. And Schuster was a clerk in a shoe store and saw Willie Sutton walking down the street in Brooklyn. Like, whatever. Schuster calls the police and says, "I think I've got some information that could help you capture Willie Sutton." And they, "Oh, that's great, give it to us." He says, "No, I'm scared to death. This guy is really a bad guy. I want you to promise me protection if I come forward." The cop said, "Absolutely, we'll protect you." Schuster tells the information, Sutton's arrested, Schuster is murdered. How's that case easier, Adam, for Schuster? For Schuster's estate than Linda Riss's case?
I would say there was a special relationship created between the police and
Being more precise, how was that relationship different than Linda Riss's relationship with the police?
They assured him protection.
Have we seen this before?
Probably.
Yeah.
It's like the undertaking with the guy who was dying in the back of the car,
Yep.
and he just left him there.
Of course, they took charge of a helpless person there. But if we have a more generic rule about any time a person makes a promise that someone relies upon for safety, like brakes or us, is it unfair to make the person live up to that promise? Is it unfair to make the defendant who voluntarily goes into the business of fixing brakes not be able to walk away when they do a lousy job of it? Do these cases have the same floodgates concern, Adam?
Yeah, I would think so.
Who wants to push back on that? Far, far less of a floodgates concern. Shit.
The police actually have control of how many they can allow in.
True. So, do you think police promise everybody they encounter that we're going to protect you? Might they do that for some? It might be up to them whether to provide that promise or not. So this scarce capital, they control that. It's not the jury controlling the promise, it's the defendant himself controlling the promise. Another argument. Yeah.
Not as many people get murdered as don't have their calls responded to by police.
So, might this be a pretty limited situation when the police have asked for help,
right,
and this guy steps out of the crowd and says, I'm not just Linda Riss, I'm giving you something more than my tax dollars.
Right.
I'm giving you information you are asking for in return for a promise.
And also he's being a good Samaritan.
Being a good Samaritan. Linda Riss was just looking out for herself, which is perfectly fine, but that distinguishes her from the plaintiff in the Schuster case. How about the subsequent case? Are you, Kimberly, any stronger on the second case, the Long versus Erie, the 911?
So in that case, basically, caller called in to say that someone breaking or trying to rob the house, and called to request for the police to come and help, and basically the person picking up the call from 911 said, asked for the address, and the caller said it was 319. The transponder wrote down the wrong number, wrote 219 instead. So as a result, the police went to what they thought was 219. There was no place that was that address, so they called back to get the...
So how's this case easier for the plaintiff than Linda Riss's case?
It's easier because the person who called provided the information and relied upon the police showing up. They didn't...
Just abstractly? Like, oh, when I call the police, I'm sure they're going to show up.
I mean, they expected the police...
Was there a specific language here that supports the plaintiff's claim?
The responsibility of providing that duty.
And what was that conversation between the 911 dispatcher and the plaintiff?
I don't have it book in front of me, but I believe it went something like, I need you to come here now, and she said, okay.
Okay.
Right.
Okay. Is she any longer a stranger to the police when the police say, tell me your address, and we're going to send somebody? Okay.
And then right away.
And they didn't follow it up. Okay. Adam, easier case for the plaintiff?
Yeah.
Same argument, basically. Does the state have to set up a 911 system?
Do they have to?
Could they get out of the business of this kind of civil liability pretty easily if they chose not to have 911 people ever promise to provide assistance? Is that a little harder for Linda Riss's case? The police to get out of the business of stopping crimes?
Yes.
Yeah, they don't control this. It's much more fluid situations. There are 911 calls, specific promises. These are carve-outs the courts have recognized despite the public duty rule. Let me add, and mention in the case books, a couple other situations besides police protection. Fire protection and safety inspectors. The case book mentions this horrible case in North Carolina in which this chicken processor locked all the exits so that the employees couldn't go out and have a smoke during breaks. And a town inspector saw these locks, wrote them up, but didn't follow up. Fire broke out. Dozens of people were killed. Defendant raised a public duty argument. Adam, why might it work?
Because they...
Are they sort of like cops?
Sort of, yeah. I mean,
How?
they were involved in the enforcement of these regulations.
Right. Just like cops are involved in the enforcement of criminal laws.
Right.
Why might they similarly be entitled to this public duty exception that says you can be negligent and not face liability? Exam question. Right? Take something you've seen and, yeah, bam.
Because they owe duty to the whole public. Not
Yeah.
just, the people at the chicken, whatever that was.
A public safety obligation as well?
Yeah.
And might it be tempting for courts to say the same principles that support no liability for cops supports no liability for firefighters and no liability for inspectors, absent a specific promise that someone relies upon? And it turned out these poor people in the factory had no idea that an inspector had come through and made his report and did nothing about it. So they had no special relationship, no promise had been made to them, unlike Schuster and unlike the 911 case. So now, it's done. I'm sorry.
Oh. Yeah, I was gonna say, isn't the burden quite low for the, what was it, the fire inspector?
Yep.
To follow up on the locks, whereas with the police, it's a different case because it would have been a burden to follow.
But yes.
Okay.
But are we looking to try and find a bright line here that takes government entities off the hook for failing to protect the safety of the public, even when we think they should have done it better? The answer is yes. Can you distinguish this maybe from Linda Riss's case? Maybe, but the courts haven't.
Okay.
Now, Ms. Dunham. My boyfriend is beating me. Please come to 319 Logan Court. Policeman comes. There's evidence of a physical altercation. Tell your classmates what mandatory arrest law.
Sure. So in Rhode Island, we have mandatory arrest laws for domestic violence cases. And so with that, if you fall under the umbrella of a domestic violence call, then the police have to arrest the primary aggressor in the situation. And so in this case, it would be the boyfriend who is beating the girl.
Okay. We're going to go a couple different directions here. One is, and I just asked the library to check this, 32 states have some form of a mandatory arrest for domestic violence statute on the books. Rhode Island is one of them. Rhode Island is one of about 20 that make it mandatory arrest in all situations if certain characteristics are there, like a physical injury, evidence of a felony, and the like. Another dozen or so, including Massachusetts, make it presumptive arrest, but only mandatory when there's actually a court order that's been violated. Okay. So let's start. Why might states have imposed these statutes? Might Linda Riss's case have been floating around in the atmosphere when advocates were looking at this kind of situation?
So I think in general, domestic violence is a unique crime in the power dynamics that there are. And so there's often signs of lethality in these physical abuse situations.
Why don't police always arrest, historically?
Because there's probably a lot of different reasons. I mean,
Well,
there's
come on.
the discretion they're using.
Stop right there. Didn't I say there's a through line here about the exercise of discretion? Are we willing to say every time a policeman doesn't stop a speeding car and an accident ensues, that the victim of the accident should be able to sue the police for failure to arrest? Sounds attractive to me. A crime was committed. They got the radar gun. No state allows that liability. Why? Yeah.
An officer only has so much time, and so they need to be able to prioritize more serious violations.
Yeah. So, and is that a matter of police discretion? Where do we send most of our armed law enforcement people? Where do we send our EMS people? How do we staff this complicated world in which we live, in which crimes are either happening or might be happening all the time, and we have finite resources? And so, why might that have become a carve-out? Why might now these 32 states saying, okay, we get the general problem about reluctance to impose police liability for failure to arrest, but what's different here? What might have been happening in the 1990s that led all these states and Congress actually to pass a federal statute to encourage the passage of these statutes? What was happening?
Well, I think the risk of harm is a lot higher than a speeding ticket.
So was there more data? Were there more reports coming out about domestic violence?
Yes.
Why was that why was that as a particular underreported crime category?
Multiple reasons.
You keep saying multiple.
I mean, it's a complex issue. I think, a lot of people try and hide what happens behind closed doors, especially within the institution of marriage.
Good.
There's, a lot of emotional trauma associated with it, so that makes for the
Might
social
some people be embarrassed to report that their primary relationship is having this terrible problem?
I would argue also, like the amount of people that would recant because they were scared of retaliation. So the police, if you take the aggressor out of the house, you kind of take the decision away.
Well, we'll go in a second, but why in the 1990s did this come up?
Well, and maybe those who did report, who knows if the police actually were able to. I
can tell you personally, I was a junior lawyer at my firm. And what happens at big firms is your wealthy clients don't just have business problems, they sometimes have kids problems. And this kid, who was a student at American University, was being stalked by an ex-boyfriend. And she was scared to death. He slashed her tires, he left her threatening notes. And so she told her dad, eventually her dad told a partner, and her partner called me and said, you go to the local authorities and get them to arrest this son of a bitch. And I had no background in domestic violence. I had only sparse encounters with police, but when you're the rookie lawyer, you go do it. And they sort of laughed at it. And they said, she's going to recant. She's not going to be a reliable witness. It's a waste of my time, our scarce resources, to go out there and get involved in this. Now, if he hit her, come back and I just was completely flabbergasted by that. But it was a pretty common attitude, in particular from men. And so it's not a coincidence entirely. This stuff started changing in the 1990s when women became more influential in our political system. We'll talk in our last class about a group called Mothers Against Drunk Driving, who basically changed a whole area of civil and criminal law in our country by virtue of just standing up and saying, we will not be silenced any longer. And this happened with domestic violence as well in the 90s. And so as a consequence, we now have mandatory arrest statutes in many states. Who wants to argue against that? Why are there some legitimate concerns about requiring police to always arrest every time there's evidence of domestic violence?
Because if the wife didn't call the police, the boyfriend might think, or husband might think she did and retaliate when he gets home. And if she can't get away, then that's a massive problem. And like she said earlier, you take that choice away from the wife or the girlfriend.
And you take the choice away from the policeman to make the sort of in the context call about they seem to have calmed down. This has happened before and things went okay after this. I'm not going to take this guy down to jail. What might putting him in jail do to that relationship? You suggested one possible consequence.
Or she might also still psychologically be like kind of...
Who's the enemy now? The police? Who's now the real bad person in this?
Depending on if she still is kind of struggling with whether she loves him or not, definitely the police.
Yeah, and how about from the point of view of the guy who's in jail?
The girlfriend or the wife.
And he's going to get out at some point. Almost always. So this is an enormously controversial area of law that is against the backdrop of the Linda Risk case and this concern that we don't want there to be a general opportunity for people to sue for failure to arrest. Now, it's done. If the statute's on the books and the cops don't arrest, and the violence happens, now we've got a winner despite the public duty rule? Let's hear the argument.
I mean, there's a legislative rule in which says that you must arrest if, these things are happening.
Is this sort of a negligence per se situation?
I would say so, yeah.
You have a specific statute directing the police to do something in certain circumstances. Assume the facts are all lined up and they don't do it. Is that a very strong policy position to resist liability from, as opposed to the Linda Riss case? Which one is a less attractive argument for immunity? The Linda Riss argument or the cop saying, don't make me pay damages when I violated my obligation under the Rhode Island statute to engage in a mandatory arrest? Which one are you more comfortable sending to the jury?
The negligence per se case.
Talk about it.
I think the policy in of itself is meant to protect a class of people, which would be victims of domestic violence.
Exactly.
It's also meant to protect them from the risk of harm, which would be, in certain states, just the physical abuse. I will say...
Is there less of a floodgates problem here?
I don't think so, because it's...
Is there less of a floodgates problem than Linda Riss's case?
Much less.
Why?
It's a more specific issue. It's dependent on a relationship between two
And the
people
cop
and a type
is
of-
actually there making the cost-benefit analysis and decides to walk away from the situation, which is different, I think, than the cops in the station house getting 15 calls and trying to feel which of these 15 are going to be the ones that we send police out to do. So you can get police liability under certain circumstances, but it's going to be hard if the theory is just simply you fail to intervene to stop a crime against a citizen.
And just in response to the sort of argument against it, so with Rhode Island, they mandate on top of the arrest, there's a no contact order put into place between the victim and the perpetrator.
Good.
So this is something that the victim would have to go to a judge and have the judge lift based on whether or not the judge feels that...
And why might those cases be strong cases for carving out an exception to the public duty rule? Why is that probably the very best argument for making police be liable when the potential victim gets a court order, a no contact order, and then it's violated? Why does that have a lot of intuitive appeal, more so than the Linda Riss case? Why? Have we had a determination of dangerousness by a neutral government officer? Is it directed towards two specific people in the community? Is that going to be a lot less of a big problem than the sort of infinite liability for all the cases where police don't stop crimes problem that is behind the Linda Riss general rule that says police have no obligation to stop crime? So in most states, if there's a court order and the police know about it and they don't intervene, that becomes a basis of liability as well. And does that show us a special relationship then? Not Linda Riss, the poor taxpayer, but actually Mary Jones, who's gone to court and gotten the state saying that Burton Pugach is dangerous. So, I'll just leave you with this. You may have seen it in the case book. You remember that Burton Pugach said the night before the acid was thrown, if I can't have you, no one else will, and when I get finished with you, no one else will want you. When he's released from prison, he married Linda Riss. I'll see you after Thanksgiving.